Today, we're looking at a piece arguing that the justice system is using a smuggling scandal involving the Shin Bet head's brother to oust him, while ignoring similar issues with other top officials.
Right. It's a very potent double standard argument. But the way it's built right now, I'm a little worried it could collapse under its own weight for a skeptical reader. So let's get into it.
Okay, so the whole piece really hinges on this idea of comparative logic, right? It's asking the reader to look at the Shin Bet head, then look at the military advocate general and the attorney general and feel the injustice.
That's the core of it, yes.
But the argument leans so heavily on comparing the Shin Bet head situation, specifically his brother's smuggling, with the conduct of the Patsarat and the AG.
And the current structure, you think it risks being dismissed as what, a false equivalency? I do, because here's the weakness, as I see it. The piece effectively equates smuggling goods into Gaza, which the text itself says is labeled aiding the enemy, with things like internal leaks or, theft of military gear.
Which to a critical audience are just not the same thing.
Not even close. Aiding the enemy during wartime has this massive legal and, frankly, emotional weight.
Right. And if I'm a reader who isn't already on board, I see that comparison and I might just stop reading. I'd think, okay, one is treason, the other is misconduct.
Exactly. The moment the reader makes that distinction in their head, your entire argument about a double standard it evaporates, because they believe the standards should be different.
So the author is trying to compare the outcome, that someone should be fired, but the reader gets stuck comparing the initial crimes.
And they're not even in the same ballpark in many people's minds. So yeah, that's a huge risk.
So how do we fix this? The suggestion here is to shift the whole focus.
Yes, completely reframe it. Move away from the severity of the crime and focus on the principle of vicarious liability.
Vicarious liability, so being held responsible for what your family member does.
Precisely. The argument should not be, is smuggling worse than leaking? That's a losing battle. The argument should be, should a public official ever be forced to resign because of their brother's or son's actions?
That's a much cleaner, much stronger question to ask.
It is. It forces the reader to consider the principle, not the specifics of the crime.
So a concrete example would be, instead of comparing the smuggling to the leaks,
you compare the family members. You write something like, if the standard is that an official must resign for a family member's criminal act, then that exact standard must be applied to the attorney general whose son stole military equipment.
See, that's powerful. It neutralizes the whole treason debate because you're focused on the family connect.
And to really make it land, I'd even suggest acknowledging the severity of the smuggling up front. Don't downplay it.
Build that credibility with the reader.
Yes. Say something like, let's accept for the sake of argument that the smuggling incident was a grave security event.
You grant their premise.
You grant it completely. And then you pivot. The question is not about the act itself, but about who is being punished for it. The perpetrator or the public official who is merely related to him.
That completely changes the rhetorical battle. You're no longer defending the brother. You're questioning the system's logic.
And that's a much stronger position to argue from.
Okay, let's move on to the Gronis Committee report. The text zeroes in on this one clause about extreme acts by family members.
It's a great find. A really key piece of evidence. The problem is how it's presented. The analysis leans a little too heavily into conspiratorial rhetoric.
Yeah, it does. It asks all these questions like, how did they know to write this clause in advance? And it sort of implies this was a trap laid specifically for this one guy, David Deeney.
And that's the weakness. When you start asking, was this an accident or did someone know where things were rolling? You start to sound a bit
paranoid?
Yeah. It risks alienating any moderate reader who's more likely to believe in, bureaucratic clumsiness than some grand conspiracy.
So the suggestion is to shift that framing too.
Right. Stop asking questions about foreknowledge. You can't prove it, and it sounds like a conspiracy theory. Instead, turn it into a sharp critique of selective weaponization.
Okay, I like that term, selective weaponization.
The clause exists. That's a fact. The real argument isn't about how it got there, it's about why it's being used now against him and not in other cases.
So an example would be replacing, did someone plan this, with something more analytical.
Exactly. You could say, the clause regarding extreme acts provides a bureaucratic mechanism that can be activated selectively. The issue is not its origin, but its application.
That sounds so much more authoritative. It's an accusation of opportunity, not psychic power.
And it's much harder to dismiss. And you can take it a step further. The text of the clause, I believe, mentions conflict of interest.
It does.
So dig into that. Instead of attacking the clause itself, show why it doesn't even apply. Say something like, The growness clause is triggered by a conflict of interest. Here is the evidence that the Shin Bet head immediately recused himself from his brother's case, rendering the clause irrelevant.
So you're not just questioning the motive, you're dismantling the legal justification for using the clause at all.
That's a legal defense. The other thing is a conspiracy theory. One is much, much stronger.
Got it. Now let's talk about the definition of security. The piece seems to dismiss the smuggling as just a carton of cigarettes.
And that's a real problem. It undermines the whole defense.
The text literally says, you get it? Cigarettes became a security event. The tone is mocking.
Very mocking. And that's the weakness. By minimizing the crime smuggling into Gaza during a war, the author just sounds biased. They lose anyone who sees any economic activity with the enemy as a major security breach.
It feels like the author's saying it's just tobacco, but the state's argument is, this is funding terror. You can't just ignore that.
You can't. You have to engage with their strongest argument, not their weakest one.
Which leads to the suggestion, adopt a steelman approach.
Yes, accept their premise for a moment, argue that, okay, it's a serious event, but then pivot to how the response is disproportionate.
So a concrete example of this would be to say,
You could phrase it like this. Let us grant that smuggling anything to Gaza is a security breach. The question then becomes one of consistency. When the Batzarit leaks information that serves enemy propaganda, that is also a security breach.
So you're comparing a breach to a breach, not cigarettes to leaks.
Precisely. And then you hit them with the follow-up. Why is one act labeled aiding the enemy while the other is treated as a mere procedural error?
That's the question that really exposes the double standard.
It does. And you absolutely have to cut phrases like, it's only cigarettes.
Definitely.
Replace it with something like, the object itself, whether cigarettes or documents, is irrelevant. The legal classification of security event is what matters. We must demand that this label be applied consistently.
That's so much more powerful. It's not an excuse. It's a demand for consistency under the law.
It turns a defensive crouch into an offensive argument.
Okay, let's revisit the Attorney General comparison. The piece brings up her son stealing military gear, but it feels a little anecdotal.
It does. It says he stole a military vest with magazines and then notes no committee, no anomalous clause. It comes off as a bit of a whataboutism.
Like, hey, look what her kid did. It doesn't really connect the dots procedurally.
Right. It doesn't prove that the AG herself was shielded from a policy. It just says her son did a bad thing and nothing happened to her. The link is weak.
So, to strengthen it, the suggestion is to tie it back to that same conflict of interest framework from the Growness report.
Yes. Make the parallel explicit. Ask the right question. Did the Attorney General have to formally recuse herself from her son's case? Was there a committee to evaluate her position?
And if the answer is no, or she just did it quietly without being forced,
Then that's the core of your comparison. That's the direct parallel to the Growness clause trying to force the Shin Bet head to resign.
so you could build a sentence that directly contrasts the two outcomes.
Exactly. Something like, in the case of the Attorney General, the system allowed for the separation of the parent from the child's action. In the case of the Shin Bet head, the Growness clause is being used to explicitly conflate the two.
And then the punchline.
This structural discrepancy, not the individual acts, is the real injustice.
That makes it about the architecture of the system, much more sophisticated.
It's an argument about law, not about personalities.
Finally, let's touch on the overall tone. It's very emotional.
It is. It's full of these little asides like, wow, exactly fitting the situation, or, excuse me, just so we understand.
Or they mark a target. It feels more like a rant than a piece of analysis.
And it's just preaching to the choir. Anyone who already agrees will nod along. But if you're a skeptic, you hear that wow and you just tune out. You think, okay, this person can't be objective.
So the suggestion is pretty simple. Cut the shocked internal monologue.
Just cut it all out. Replace it with cold, hard assertions. Let the facts themselves create the outrage in the reader. Don't tell them to be outraged.
I love that. So instead of, where was that same determination in the Patzeret's affair, which sounds a bit whiny,
You state it as a fact. The system displayed a clear lack of determination in the Pazaret affair, evidenced by the absence of any aiding the enemy charges.
it's declarative, it's undeniable.
And it's far more damning. Same with nothing is accidental. That sounds like a movie tagline.
So instead,
Rephrase it to sound like a legal analysis. The timing of these events suggests a coordinated effort rather than a simple procedural coincidence.
it's the same core idea, but one sounds like a serious analyst and the other sounds like an angry blogger.
Exactly. When you take out the wows and the excuse me's, the argument gets louder, not quieter. because it becomes so much harder to dismiss as just raw emotion.
So, to wrap this all up, the raw material here is fantastic. I mean, the inconsistencies are glaring, but the piece needs to mature from a passionate op-ed into a forensic indictment.
I agree completely. The author has all the right puzzle pieces. They just need to fit them together with precision, not force.
So, a quick recap of the actionable points for our listener.
Let's do it.
First, validate the severity of the smuggling. Grant the premise to gain credibility, then immediately pivot to the inconsistent application of liability.
Second, stop attacking the creation of the Groenies Clause. That's a conspiracy dead end. Attack its selective application. It's not about how they knew, it's about why they're using it now.
Third, strip out the emotional language. No more wows or you get it. Let the cold facts do the talking.
And fourth, draw a much sharper legal parallel to the Attorney General. Focus on the structural difference. One system separates parent from child, the other conflates them. That's the injustice.
If these changes are made, this piece really could become a serious piece of commentary that demands a real answer.
It moves from being an angry post to a formal accusation that the system has to address. It goes from noise to signal.
We would genuinely love to see the revised version of this. Please, sharpen these arguments, rework the draft, and send it back to us for a final.
Really looking forward to reading it.
Thanks for listening to The Critique.